Mm.
Did you want me to let them in at 2:02 still?
Sure.
Unless you want them in now. It's up to you.
We can do it now.
All right, stand by.
Good afternoon, everybody. As you're joining, we had a number of people register, so we're going to let in everyone. Thank you for joining this afternoon. See many people joining us. Because there's a lot to get through today, I'm going to start us off. My name is Golden McCarthy, and thank you everyone for joining us today for this webinar on addressing unlawful child labor in our communities. We will start with welcome remarks by the Administration for Children and Families Assistant Secretary January Contreras, and then Bridget Dutton from the Department of Labor's Wage and Hour Division will lead in the webinar. After that, the two of us will have a quick discussion on practical steps we can all take in addressing unlawful child labor. Although we won't have time for live questions, we would still take questions in the comments. And after the presentation, we'll send out a recording, the slide deck, and responses to all your questions. So with that, I pass it to January Contreras.
Thank you, Golden, and thanks to everyone who's joined us today. This is going to be a great training by our wonderful partners at the Department of Labor, and we're so glad to really expand this message to our partners in the human services field and health services across the country. That's what today is about. We do see an increase in child labor exploitation across the country, and ACF has a role to play. We know that many of the youth that we serve are going to be targeted for labor exploitation. That includes our young people we serve who are recent migrants to our country, our unaccompanied children that we serve, young folks in our refugee program, kids and youth coming out of the foster care system, those who seek services through our runaway and homeless youth program. We serve a lot of young people who are going to be targeted for exploitation in one way or another. And so at this time, we're focused on child labor exploitation. What is it and how do we respond and what are the tools that we have? So A, thank you for being on this call, but B, thank you so much for being committed to the well-being of all the kids and youth and families that we serve across the country. Because I know if you're on that call, that's what you're choosing to do in your life and in your workplace. So thank you for that. This is something we're going to take on together and keep informing ourselves and providing tools so we can help prevent child labor exploitation. Thank you so much.
Thank you, Assistant Secretary January Contreras. I've had the pleasure of working with the Department of Labor and Bridget Dutton specifically. I sent out a bio that about her. She's been with the Department of Labor since 2001, and in reviewing her bio, she has worn so many hats and has such a clear expertise in this field. So I'm very excited for her to share all of her knowledge. Again, after the presentation, please stick around. We're going to have a brief discussion about practical applications of what she's going to present on. And then we'll be sending out a number of resources after this training. So with that, I'll pass it on to Bridget Dutton.
Thank you, Golden. Let me get my slide deck up. And Golden, if I could just get a verbal, you can see the slides.
Yes, it looks good on my end.
Great. Yeah. Thank you so much. And thank you to January for that wonderful introduction. And thank you all for all of the hard work that you do. We're so excited to be partnering with you and to be sharing more on how we deal with child labor at the Wage and Hour Division today. So I'm going to walk through an overview of who we are and what we do and how we engage in workplace protections. through enforcement and outreach. We specifically will discuss child labor rules and aspects of our investigation process, and we'll highlight how the public can file a complaint with us and information needed when doing so, and discuss the resources we currently offer related to child labor. So we are here to discuss child labor with you specifically, but first, in case you aren't aware of who we are, I want to walk you through our laws and statutes, because we are responsible for enforcing some of the nation's most comprehensive federal labor laws. So our mission is to promote and achieve compliance with labor standards to protect and enhance the welfare of the nation's workforce. Simply put, we want to make sure that working people in the U.S. receive the wages and protections they've earned, and that their work is respected. We are committed to ensuring that workers in this country are paid properly and for all of the hours that they work. We're also dedicated to providing employers with the tools that they need to operate in compliance with a variety of labor laws that we enforce. So at the Wage and Hour Division, we help workers, advocates, employers, and other stakeholders understand worker protections and employers' responsibilities. Collectively, our labor standards protect over 165 million workers in more than 11 million establishments nationwide. Our work reflects our strong commitment to protecting workers, with more than 200 wage and hour offices across the country and over 200 languages spoken amongst our staff or through the use of translation services. We were created with the enactment of the Fair Labor Standards Act of 1938, or FLSA, as you will be more familiar with. The division covers virtually all private and state and local government employment. We're comprised of a nationwide staff of investigators, supervisors, and technical and clerical employees responsible for enforcing these laws. We consist of 5 regions, as you can see shaded on your screen, and 200 local district offices throughout the country. And when you receive this slide deck, you can see that I've hyperlinked our offices so that you can access all of our locations, addresses, district directors, and our community outreach specialists who are experts in compliance assistance. As we look at the work that the Wage and Hour Division does, I wanted to lay out how we prioritize that work. First, we focus on prevention. We are reinforcing our relationship with workers, their advocates, and employers through outreach and education to help prevent wage and hour violations from occurring in the first place. Second, we focus on compliance. We're providing compliance assistance so that we can ensure early detection and correction of problematic wage and hour practices. And finally, we focus on enforcement, which means we provide regulatory certainty by enforcing the laws fully and fairly. So I mentioned to you that we are responsible for some of the nation's most comprehensive federal labor laws. So I want to briefly walk you through each one of those so that you are more familiar. First, as I mentioned before, the Fair Labor Standards Act, or FLSA, is the federal law commonly known for minimum wage, overtime pay, child labor, record keeping, and special minimum wage standards. Those are applicable to most private and public employees. The FLSA provides the agency with civil and criminal remedies and also includes provisions for individual employees to file private lawsuits. The Family Medical Leave Act, often referred to as FMLA, entitles eligible employees to 12 weeks of unpaid job protective leave for certain family and medical reasons. At the employee's or employer's option, certain kinds of paid leave may be substituted for unpaid leave. Employees are eligible if they have worked for a covered employer for at least 1 year and for 1,250 hours over the previous 12 months, and if there are at least 50 employees within 75 miles. So the employee may be required to provide advance leave notice and medical certification. For the duration of that FMLA leave, the employer must maintain the employee's health coverage under any group health plan. Upon return from FMLA leave, most employees must be restored to their original or equivalent positions with equivalent pay, benefits, and other employment terms. The government contract statutes set labor standards for wages and hours of workers for employees who work on contracts with the federal government. The Davis-Bacon and related acts covers workers on federal construction contracts and on construction contracts with state and local governments that are federally financed or assisted in whole or in part. The McNamara-O'Hara Service Contract Act applies to workers on federal service contracts. The Migrant and Seasonal Agricultural Worker Protection Act, or MISPA as we like to call it, sets standards for migrant and seasonal agricultural workers regarding wages, housing, and transportation. MISPA requires that contractors of migrant agricultural workers register with the federal government and notify prospective workers of the wages and working conditions before they are hired. MISPA also requires that providers of housing to such workers comply with certain minimum standards for health and safety, and that transportation providers have vehicles that meet certain standards for safety. The Employee Polygraph Protection Act prohibits most private employers from using any lie detector tests, either for pre-employment screening or during the course of employment. Polygraph tests, but no other types of lie detector tests are permitted under limited circumstances subject to certain restrictions. The wage garnishment provisions of the Consumer Credit Protection Act protect employees from discharge by their employers because their wages have been garnished for any one debt, and it limits the amount of an employee's earnings that may be garnished in any 1 week. This act also applies to all employers and individuals who receive earnings for personal services, including wages, salaries, commissions, bonuses, and income from a pension or retirement program, but ordinarily not including tips. We have certain responsibilities in the Wage and Hour Division under the Immigration and Nationality Act. These include enforcement of the labor standards protections for certain temporary non-immigrant workers admitted to the U.S. under several programs. Those programs include D1 for crew members, H1B for professional and specialty occupation workers, H1C for nurses, H2B for non-agricultural workers, and H2A for agricultural workers. And I know that was a mouthful, but we have lots of information to give you on each of those acts if you so desire. Now that I've shared information and an overview on the laws we enforce, let's specifically discuss what we're here for today, and that's our child labor provisions. We are dedicated to helping young workers find those positive and early employment experiences, but the work must be safe in doing so. The child labor provisions of the FLSA were enacted to ensure that when young people work, the work does not jeopardize their health or their well-being. So generally, the minimum age for employment is 14, although there are some exceptions and exemptions for children under the age of 14 that allow them to babysit on a casual basis, deliver newspapers, or work as actors or performers, for example. However, the Fair Labor Standards Act groups children into 2 categories for employment purposes. 14 and 15-year-olds are grouped into 1 category, and then the other is for 16 and 17-year-olds. Simply stated, employees aged 14 and 15 years of age may only work outside of school hours and only for certain time periods, which we will discuss further. They may only work in non-manufacturing, non-mining, and non-dangerous jobs. However, employees that are age 16 and 17 years old may perform any job that is not considered dangerous and with no limit to the number of hours that they work. The child labor regulations do not apply to any employee that is 18 years of age or older. Last, there is a parental exemption for a person who is the sole owner of a business. A child who works for a company that is entirely owned by their parent may work longer hours, and they also have fewer job restrictions. In this case, we do ask that you reference fact sheet 43, and we can share that along with the other materials for more information. So the number of hours that a 14 and 15-year-old may work depend on whether school is in session. For example, when school is in session, 14 and 15-year-olds may not work more than 18 hours. However, when school is not in session, 14 and 15-year-olds may work up to 40 hours in each work week. Additionally, 14 and 15-year-olds may only work between the hours of 7 a.m. and 7 p.m., except from June 1st through Labor Day, when the evening hour is extended to 9 p.m. Hour standards violations are very common when discovering child labor violations for 14 and 15-year-olds. Let me point out that many states do have different standards, and employers should check with both state and federal agencies to ensure compliance. Where state and federal laws are different, the most protective law will apply. So let's share work that 14 and 15-year-olds can do and work that 14 and 15-year-olds generally cannot do. And the work that they can do includes being a cashier, modeling, artwork, advertising, working as a dishwasher, completing office and clerical jobs, bagging and carrying out groceries, food prepping by hand, serving as a busser or server at a restaurant, stocking shelves, and then certified 15-year-olds may work as lifeguards at swimming pools and amusement parks. Work that they generally cannot do in the ages of 14 and 15 are any work involving manufacturing, mining, or processing, baking or cooking, serving as a public messenger, construction work, including roofing, using or cleaning power-driven equipment, loading and unloading equipment, working in or around freezers or coolers, and door-to-door sales. Although up until this point, we've been making the distinction between children who are 14 and 15 and those that are 16 and 17, dangerous jobs applies to all children under 18 for work that is not on farms. You may be asking yourself, what's a hazardous occupation, also known as an HO? An HO is work that the Secretary of Labor has determined is too dangerous for children under the age of 18 to work. Children under the age of 18 may not perform any work covered by any of the HOs at any time, not even once, unless specific exemption applies. There are 17 HOs for work that is not performed on farms. On the next few slides, we will discuss 8 of the 17 HOs that are off limits for children under the age of 18. However, our website hosts additional information and compliance assistance materials, including Fact Sheet 43, as I referenced earlier, which provides more detailed information for the work children can and cannot do, and Fact Sheet 40, which provides more detailed information for the work children can and cannot do on farms. So our first HO is HO1, and it involves work in manufacturing or the storing of explosives. Children generally cannot work in factories, warehouses, or other places where explosives are produced or even stored. Some examples of violations in this context could include minors working in jobs handling or transporting explosives, operating explosive manufacturing machinery, or participating in activities related to the detonation or disposal of explosives. HO number 2 bans driving motor vehicles on public roads and working as outside helpers on motor vehicles. Children generally cannot drive a car, truck, or other vehicle for work or ride on the outside of the vehicle. There are special circumstances for 17-year-olds only, and Fact Sheet 34 will give you more information on that. Some examples of violation under this HO include delivering pizzas from a personal vehicle, operating an ATV, motorcycle, or motor scooter on public roads, and riding outside the cab on a garbage truck. HO number 4 generally bans minors from working in forest firefighting or prevention and from working in logging and in sawmills. Examples of violation include actual forest firefighting, forest fire prevention that entails extinguishing an actual fire, timber tract management, forestry services, logging, and sawmills. HO5 generally bans minors from using, repairing, or cleaning chainsaws, sanders, or other power-driven woodworking machines. Examples of violations under this HO include feeding material into woodworking machines, supervising or controlling the operation of the machines, helping the operator to feed material into such machines, setting them up and adjusting, repairing, or even oiling the machines. This also includes portable machines, battery-operated machines, and those that are considered pneumatic machines. HO7 involves the use of hoisting apparatus and generally bans minors from using, riding on, or repairing forklifts, cranes, or other types of power-driven hoisting or lifting machines. We see this commonly with children tending, riding upon, working from. You can't be repairing, servicing, or disassembling any of these machines. We can't find them in an elevator crane, a derrick, hoisting, a high lift truck, a man lift, nothing along the lines of freight elevators and operating forklifts, just due to the potential dangers involved, such as tipping or collisions. HO10 involves meat and poultry packing or processing, and children generally cannot work in slaughterhouses or meat packing facilities. They cannot operate, clean, set up, or repair mechanical meat slicers, meat processors, or other types of machines, even if used for things other than meat. However, there are some special exemptions that apply to this HO for student learners and apprentices. And again, you can reference fact sheet 43 to learn more. All occupations involved in slaughterhouses, on the killing floor, curing cellars, and in hide cellars are particularly hazardous, including the recovery of lard and working in boning occupations. Minors under age 18 may not operate meat slicers. The operation of meat processing equipment, such as grinders, patty formers, and slicers, is prohibited no matter where performed, even in restaurants, delis, and cafeterias. HO11 involves working with bakery machines and generally bans children from using, operating, cleaning, maintaining, or repairing mechanical dough mixers, dough rollers, or other types of bakery machines. 14 and 15-year-olds may not perform any part of the baking process, such as weighing and mixing ingredients, placing or assembling products in pans or on trays, operating ovens, including convection ovens, toaster ovens, pizza ovens, automatic feeding ovens, and microwave ovens, except those microwave ovens used for warming food. Removing items from the oven is prohibited, as well as placing items on cooling trays and finishing baked products. HO number 12 involves work with power-driven product machines like compactors and balers. Minors generally cannot use, load, unload, clean, or repair these machines. In some circumstances, 16 and 17-year-olds can load, but not unload certain machines used only for paper. Generally, minors under age 18 may not load, operate, or unload scrap paper balers and paper box compactors. This includes equipment that processes other materials in addition to paper, such as trash, aluminum cans, glass, and foam rubber. There are major differences between what children can do on farms versus off farms. Although they both have age limitations, hours regulations, and HOs are dangerous jobs, the rules are applied differently. Once a child reaches age 16, the child labor rules no longer apply to farm work, and they can do any job on a farm at any time. Children who are age 14 and 15 working on farms are restricted to working outside of school hours, but for an unlimited number of hours. However, they are banned from working in dangerous jobs. 12 and 13-year-olds may also work on farms outside of school hours and are banned from working in dangerous jobs. However, they must either work on farms where their parents or guardians work or have written consent to work from a parent. Children under 12 years old may work outside school hours in non-dangerous jobs with parental consent, but only on small farms where none of the employees are subject to the provisions of the Fair Labor Standards Act. This slide shares what children under the age of 16 can and cannot do on farms. They can operate garden-type tractors, work with dairy cattle on a range, and use ladders. They can harvest and drive vehicles on the road, but they cannot drive on a public road. However, they are specifically not allowed to work in dangerous jobs, which includes operating a tractor or using certain machines like corn or cotton pickers, and they cannot work in a yard, pen, or stall occupied by a bull or horse. They are also specifically not allowed to work from a ladder or scaffold over 20 feet or handle or use toxic chemicals. As shown in the previous slide, children working on a farm that are under age 16 are also banned from working inside a fruit, forage, or grain storage designed to retain an oxygen deficient or toxic atmosphere, or work in an upright silo within 2 weeks after silage has been added or when a top unloading device is in operating position. They also cannot work in a manure pit or a horizontal silo while operating a tractor for packing purposes, as these jobs have been determined to be very dangerous on farms. So now that you're more familiar with the laws we enforce, particularly that of child labor protections, let's discuss how we daily enact key strategies of enforcement, outreach, compliance assistance, and the declaration of regulations that promote compliant behaviors in order to impact compliance levels. To achieve our mission, we do draw on a set of tools that include enforcement of both complaint and directed investigations, partnerships with agencies, community organizations, business associations, and other stakeholders, and outreach and education to employees and employers. By using these tools, we measure success in terms of improving compliance levels so that we find fewer and fewer workers who will have been subjected to violations. Each year, we conduct strategic enforcement and education drives in low-wage industries where the division has observed historical and persistent violations of federal wage and hour laws. These initiatives include agency-initiated investigations that are aimed at identifying and remedying common violations, as well as compliance evaluations that inform wage and hour of the severity of noncompliance, the likely causes, and help point to strategies for addressing industry-specific issues. With greater access to technology, data, and evaluation methods, we have strengthened how we identify and prioritize industries for enforcement. We rely upon a data-driven methodology that combines both statistical indicators of probable minimum wage and overtime violations across industries with our own enforcement data. We further rely on a series of evaluations, research, and emerging data practices developed through the strategic planning process to focus resources on specific sectors within those industries where local enforcement may have the greatest effect. As many of you know, we recently announced a new child labor initiative as well. We often focus on industries where data and evidence show us violations are high and workers are more likely to not complain. We help workers in healthcare, grocery stores, public transportation, restaurants, meat processing, construction, agriculture, delivery services, education, and countless other industries. Unfortunately, we find child labor in many of these industries and in violation. If a worker or their advocate has reviewed our information and believes their workplace rights have been violated, they have a right to file a complaint with us. One of the goals of our outreach programs is to ensure that workers know how to reach us, know how to file a complaint, and understand that we pursue complaints regardless of the worker's immigration status. They can contact us at our phone number as indicated on the screen. They can go to our website or visit our local offices across the country. Complaints are confidential. We do not share complainants' names with employers or even let them know that a complaint was filed. So who can file a complaint? Well, a worker can, a parent or guardian can, school officials, other employers, advocacy groups, or other agencies such as yourselves on behalf of a youth. So as someone decides that they want to reach out to the Department of Labor Wage and Hour Division for a complaint, information that we find useful in filing a complaint with us includes the person's name, the address and phone number, how the person can be contacted, and what are good times to return a call, the name of the business where they work or worked, the location of the company. This could be different from where they actually worked, the phone number of the company, the manager or owner's name. Who should we speak to when reaching out to that particular business? The type of work that was completed, how and when they were paid. For example, they may have been paid by cash, by check, every Friday, every Thursday, etc. Any additional information that a worker can provide, such as copies of pay stubs, personal records of hours worked, or other information, can be very helpful to help us decipher the employer's practices. These pieces of information are certainly not required. So if you feel like you cannot help a worker come up with all of these things, that's okay. We do ask if you have them, they can just help us build a stronger case. So now on to the investigative process. Regardless of whether an investigation is a complaint or something that we directed here at our agency, we follow the same process. We often go in unannounced into an employer's business. This allows us to observe what is happening on site and prevent the employer from destroying records and intimidating or hiding employees who might provide us with accurate information. This slide shows the typical steps in a wage and hour investigation, but be aware that the order of events will change depending on the circumstances. So initially, our investigator will hold an initial conference with the employer and or the employer's representative and tour the establishment or the business. In a child labor case, we want to see if we notice young-looking workers or youth working in areas where they shouldn't. Our investigator will interview the employees in private, and the purpose of these interviews is really to verify the employer's payroll and time records, to identify workers' particular duties in sufficient detail, to decide which exemptions apply, if any, and to confirm that minors are legally employed. Interviews are normally conducted on the employer's premises, but in some instances, present and former employees may be interviewed at their homes or by mail or telephone. The investigator reviews the employer's records to determine compliance, examination of payroll, date of births of children, time records, and taking notes or making transcriptions or photocopies is essential to the investigation. We do hold a final conference with the employer and or the employer's representative to discuss any violations found and how to correct them. If back wages are owed to employees, the investigator will request payment of back wages. And the Fair Labor Standards Act gives the Department of Labor the authority to recover back wages and liquidated damages to be paid to employees and to assess civil money penalties in instances of minimum wage, overtime, child labor, and other violations. Please note that the employees who have filed complaints or provided information cannot be discriminated against or discharged on account of such activity. If adverse action is taken against an employee for engaging in protected activity, the affected employee or the Secretary of Labor may file suit for relief, including reinstatement for his or her job, payment of lost wages, and damages. I wanted to talk to you about a recent case where the Wage and Hour Division encountered some of the most significant child labor violations in our history. We have seen alarming trends in child labor violations over the past 5 years, including a 69% increase in the number of minors employed in violation of child labor laws. In the last fiscal year, we found 835 companies operating in violation of child labor laws affecting 3,800 children. We have noted a 26% increase in minors employed in hazardous occupations and found nearly 700 minors employed in hazardous jobs. Over the past year, we've investigated some of the most egregious violations that we've seen in years. For example, in an investigation of one of the nation's largest safety sanitation service providers, Packers Sanitation Services, Inc., also known as PSSI, we found children in slaughterhouses, on the kill floor, exposed to caustic chemicals as they clean dangerous equipment like bone saws and meat grinders. Children as young as 13 years old put to work in appalling conditions on overnight shifts in 13 meat processing facilities in 8 states. Investigators learned at least 3 minors suffered injuries while working for PSSI. We began our PSSI investigation in August of 2022, and in November of 2022, the Solicitor's Office filed a complaint in the U.S. District Court of Nebraska based on evidence that the company had employed at least 31 children from ages 13 to 17 years of age in hazardous occupations to clean dangerous power equipment during overnight shifts. The U.S. District Court issued a temporary restraining order in November of 2022, forbidding the company and its employees from committing child labor violations. In December of 2022, the U.S. District Court entered a consent order and judgment in which the employer agreed to comply with the FLSA's child labor provisions in all of its operations nationwide, and to take significant steps to ensure future compliance with the law, including employing an outside compliance specialist. In February of 2023, PSSI paid $1.5 million in civil money penalties for its employment of at least 102 minors in hazardous occupations at its facilities. This slide summarizes some of the main activities and contributions that we at the Wage and Hour Division make to support the prevention and elimination of human trafficking. We actively engage and collaborate with federal and state law enforcement partners by participating in over 80 human trafficking task forces across the country. We are uniquely positioned by often being the first government agency in a business to detect and refer possible human trafficking indicators identified during the normal course of an investigation. When such indicators are detected, we follow established protocols to make referrals to our law enforcement partners. When requested through proper channels by another federal agency, typically an assistant United States attorney or criminal law enforcement agency, we will provide advice or participate in the computation of restitution for victims or penalties against the traffickers. We've talked about achieving compliance efforts under our enforcement activity. Now let's discuss our memorandums of understanding and partnerships that also help us to achieve compliance. We work to build and maintain strong relationships with select nonprofit organizations that foster communication and better serve our nation's workers and businesses. Wage and Hour has MOUs with state agencies and organizations across the country concerning the various laws that we enforce. These partnerships provide for data sharing, referrals, coordinated enforcement, joint outreach, and compliance assistance. They maximize our impact and the corresponding benefits for businesses and workers. We at the Wage and Hour Division have long maintained that enforcement alone will never be sufficient to achieve our mission. Education and outreach to workers and employers has been and will continue to be one of the division's key strategies for protecting the workforce and promoting compliance. The vast majority of employers want to comply with our laws if they understand them. Our compliance assistance and outreach work ensures that employers and employees have all the tools they need to clearly understand their responsibilities to comply with the law and their rights as workers within the community in this country. So we do offer numerous resources to assist youth with knowing their rights and the knowledge of the work they can and cannot perform. The Youth Rules Initiative promotes positive and safe working experiences for teens by providing information about protections for young workers to youth parents, employers, and educators alike. Through the Youth Rules Initiative, the U.S. Department of Labor and its partners promote positive and safe working experiences that help prepare young workers for the workforce. From the Youth Rules website, which was recently updated, you can quickly access information about federal and state labor laws that apply to young workers. The website educates teens on the rules and provides information for parents, educators, and employers. Employers are responsible for the safety and well-being of their teen workers under federal law. As we previously discussed, some jobs are prohibited for all workers under the age of 18. The division has developed the Dangerous Jobs webpage as well, where you can hover over the images to learn more about those jobs where youth are not permitted to work. You can easily access either of these sites by referencing or utilizing the QR codes on the slide. We have resources to help parents, educators, and employers better understand federal laws involving youth employment, including this Young Workers Comprehensive Toolkit. And in this toolkit, you will have short videos, fact sheets, answers to frequently asked questions, and tools in languages other than English. We've also begun to heavily utilize social media to communicate our messaging around all of our laws, including child labor to workers, advocates, and businesses. These include worker stories of those who have helped and short, concise videos providing information for workers, including what youth should know. You can find our content under the Department of Labor on our own account on Facebook, Instagram, Twitter, and LinkedIn. Employees and employers can keep accurate records of hours on the job. The DOL timesheet app helps track regular work hours, break time, and overtime hours. The new version of the app also enhances the comments capability, offers multiple pay frequency options, and additional pay calculations. Features of the timesheet app include employer-employee options, calculates your pay automatically, records work hours simply and quickly. It's free for iOS and Android, and it's available currently in English and Spanish. We recently also developed a web page that lays out some of the best practices that employers can follow when employing youth. These best practices provide the employer with simple yet tangible practices that can be undertaken to avoid being in violation of child labor protections under the law. We also have a series of videos that break down our laws and their application, including the one on the FLSA as shown on the screen. And this particular series breaks down the law by various topics in order for employees and employers to easily understand what the law means and how it applies to them. Okay, we've reached the end of our slide deck, so I want to stop sharing. And I want to thank Golden for the time and the opportunity to go through all of that. And again, please reference the fact sheets and the additional information that will be provided to you. But before we conclude, Golden, we have a few questions.
Yeah, thank you so much, Bridget, for giving us this framework for understanding child labor laws and the process for investigation. Sometimes we can be the only trusted adult in the room when we're working or when we're around children and youth in our communities. So I thought it would be a great opportunity to just talk over some general concepts with you. So the first question is, in a situation where a young person shares that they were injured at the work site, or maybe they even shared that they haven't been paid for work they've done, what do you recommend we do as that trusted adult in that situation?
Well, first of all, again, I want to say thank you for being that trusted voice for these youth and their parents. And again, I want to say that we are committed to helping workers find positive, appropriate, and safe employment experiences. But if a worker or their advocate, which could be one of you, it could be a parent or otherwise, has reviewed our information and believes that this youth's workplace rights have been violated, they have a right to file a complaint with us. You can reach out to us online or call the number that's been provided in the slide deck. We will work with you and the youth to answer your questions and determine whether or not an investigation is the best route to go or the best course of action. Also, if there's an injury involved, we want to encourage you to contact the Occupational Safety and Health Administration, or OSHA. And just like us, they have a 1-800 number, or you can submit a complaint online or visit their offices in person.
That's really helpful. Thank you so much. And so could you walk us through if a youth and adult do call the Department of Labor, what will likely happen? And I know there's a general question of what if the child is worried about their immigration status? What should we know before making that phone call?
So first, I want you to know that any call to the Wage and Hour Division is free and it's confidential. So information that is shared on that call is not shared with any member of the public or the employer in question. So if you as an advocate or a parent or the youth themselves wants to ask questions, they can do so. It doesn't necessarily mean it triggers a complaint. You can call and just ask questions. That's totally fine. Filing a complaint with us is completely voluntary. So if you do decide, or the youth decides that they want to file a complaint, it can be taken over the phone. We do want to get the name of the complainant, the nature of the complaint, and whether it actually is a violation. So one of the things that we like to tell employees as well, whether it's a youth or an adult, is that your employer can't retaliate against you for exercising your rights by filing a complaint or cooperating with us during the course of an investigation. We work hard to ensure that workers know how to reach us, how to file a complaint, and understand those labor laws that cover them. And we want you to also know that regardless of the worker's immigration status, they can come to us and file a complaint. If they have worked here in the United States, they are entitled to the wages that they've earned, and they're entitled to a safe workplace.
Thank you so much for that, and also for reiterating the issue about retaliation. I think that's always a concern and a question that likely comes up. So then, knowing all of this information, how best should we as the adults in these youth lives support the Department of Labor when there is a possible investigation, or in just being aware of what's going on?
Well, I thank you today for allowing me to speak to everyone, because understanding and sharing the resources that I have provided would be an initial step. I think sharing these resources beyond this webinar and with the youth that you interact with parents, with other adults, would be the second step. And then if you hear of instances of violative practices by an employer, from a youth, from a parent, from another stakeholder, pass that information on to us. And as I mentioned before, it can just be a simple question that you may have, and you don't want to go too far with a complaint. Feel free to call us. We're there every day for questions, and we're also there to take complaints. And as I pointed out prior, we do have our interactive map that's on our website that shares all of our offices throughout the country. You can call and speak with our staff who are on the phone during business hours, but then also we have our community outreach and resource planning specialist staff. And their job is to go out in the community and share what workers' rights are and what employers' responsibilities are. So you can specifically reach out to them by phone or email and ask them questions as well.
This has been really helpful. I really appreciate your time, Bridget, and thank you to the Department of Labor for giving us your time today. It's been very insightful. As we mentioned before, we won't be doing any live questions, but Bridget and I have been collecting all of the questions that you've been submitting, and you can keep submitting them. And we will be turning around a response in addition to the recording of this webinar and the PowerPoint that Bridget has gone through with all the live links. So I will be ending this webinar with a big thank you to everybody for giving us your time and attention on this really important matter, and appreciate all the hard work that all of us do every day for youth and families. So thank you. And thank you, Bridget, again.
Thank you. Thank you, everyone.